Coba ulangin lagi. Oke, I will
Oke,
admit.
ya. everybody, fellow project manager. Selamat malam, good evening, good afternoon. Welcome to today's pranks session number 79 by PMI Indonesia chapter. We will soon start the pranks webinar. I'm Bimo and I'm with PMI Indonesia chapter, and I will be the moderator of today's prank session. We welcome you all to pranks. Behind the scene, we have with us Mas Rais Yuli as the pranks program coordinator, and he is coordinating the webinar event today. Pranks is a webinar, an online webinar about knowledge sharing on project management, presented by PMI Indonesia to you, project managers and PMI members. It's a regular event to exchange experience, knowledge, positive ideas, and to build networks. In pranks, we invite speakers with various background, people working as project practitioners, project specialists, and subject matter expert. Also, consulting individuals, trainers, coach, and leaders of the organization. You can join the pranks event by Zoom or watch the recorded version on YouTube channel of PMI Chapter Indonesia. And you can also subscribe and like our YouTube channel. And if you like to become a speaker in prank session, you may contact us, PMI Indonesia program section. Today's session is about digital signature, what and how to sign into the digital world. And we will have today with us Dragoljub Nesic. You can call him Nesa as our speaker. To our speaker, Nesa, thank you for joining us and for your time, sharing your knowledge and insight and experience. Yeah. A brief about our speaker. First, I have to bring this up to you. Our annual flagship event, which will be held in Jogja next month, 3rd and 4th October. And if you haven't planned to attend the CIMEX, please do so. You still have time to arrange your travel to Jogja and join many project managers, and there are a lot of speakers, interesting names in our CIMEX International Symposium on Project Management. Brief profile about our speakers. Dragoljub Nesic, you can call him Nesa. He has many years of experience in various positions and many companies. I've been in now he's a CTO in Skipo AD in Sweden. He's based in Stockholm, and he is joining us now from Stockholm, Sweden. He's also actively teaching in Stockholm University, and he is educated in business and computer science. If you want to get connected, you can check the LinkedIn and send a request and get connected, and you can ask many things about certainly about technology, and also about digital signature for sure. And before we start our session, I have to bring up to you the basic rules. that you should mute and turn off your video to maintain the focus and also to keep the sessions in a good way. And you have question, you can submit your question in the chat box. We will answer the question after, or we can also answer the question on the fly during the session, the speaker session. And this session is recorded, and you can watch the recording later in our YouTube channel. For all participants, you can have an e-certificate from PMI Chapter Indonesia, and auto submission video we will give exclusive for our member, PMI Indonesia chapter member. And give us feedback if you enjoy, and please give us a good feedback and like our YouTube channel. Okay, then I will hand it over to our speaker. Nessa, you can start your session.
All right, thank you.
Yeah.
Let me share my screen. Just a small second to get the technology up and running. Okay, hello everyone. First of all, Bimo, thank you for inviting me, and special thanks to Rahmat Muriana, my colleague from Stockholm University, who actually recommended me to Bimo for this talk. Bimo already covered a comprehensive history of what I've been doing, but in general, I'm a technologist. I worked many years in cryptography and digital signatures, and just lately decided to switch to boat navigation technology, helping people in the Nordics navigate the treacherous waters of the archipelagos around the Nordic countries. So maybe once upon a time I'll be talking about map technology, navigation, and GPS and so on. But today's topic is digital signatures, a topic that I think warmly of, and that I particularly like a lot. And let's see, get this. So I will talk about what signatures are in the physical world, then why it might be interesting to digitalize those, and then I will focus on some considerations that one may need to think about when looking at what kind of digital signatures one needs, and what are the trade-offs one needs to be aware of. So if we start with the general process of signing something, which I'm sure everyone is familiar with, there is a process of preparing the document to sign. That can be a purchase contract, that could be a will, it can be any kind of document that needs evidence of intent and understanding to be vouched by one or more handwritten signatures. So, but first of all, we need to agree on what is it that is signed, and that's the preparation phase. If we imagine a purchase contract, then we're negotiating the terms, conditions, prices, and so on. And then once we are in agreement with that, we sign that document as a matter of confirming our understanding of it and its intent. What happens then is, obviously, we have one or more copies of this document, which one or multiple parties archive somehow and store it, because a signed document without the possibility to retrieve it in the future and have a look at what is signed is not worth very much. So typically, signed documents will be archived, subject to what type of document it is. As I said, there might be one or multiple copies of it, where in a contract situation, typically each party will archive its own copy of the contract, which can then be brought forward in case of a dispute or if something needs to be checked. But once it is brought back from archives to the surface, one also needs to have the possibility to validate the signature. Is it a correct signature? Did the correct person sign, or is it a forged signature? Has somebody manipulated the document before or after? Substituted a page if it's a multi-page document, and so on. So those are the 4 phases that apply in the physical world that any kind of digital signature system needs to be able to mimic, i.e., preparing the document, signing by one or more signatories, archiving it in such a way that it can be retrieved when needed, and then being able to validate that the signature is correctly performed and the document is unmodified, and in the best of worlds, that the person or persons who signed it were indeed the individuals who were supposed to sign, and that they were in a position to sign that document. For example, that they were an officer of a company at the time of signing. One thing that we take for granted, but is worth pointing out here, is that by putting a physical signature on a piece of paper with a pen, the person doing so is implicitly confirming that they understand what they are doing. It is very seldom that a court of law would later on accept renegating on a signature by saying, I wasn't aware of what I signed. It doesn't work in real life. If you have put a signature on a physical document, it is implied that you understood what you were doing. The only possible challenge is if one can prove that at the point of signing, the person that was signing was incapacitated in some form, mentally or in some other way. That is a possible way of not being able to, not obliging the implications of the signature. But in general, it is implied, if you sign, you knew what you were doing. And also implicitly, most systems with physical signatures are designed in such a way that it should cost more than it's worth to create a counterfeit. So if the value of the document is $100,000, it should cost somebody more than that to forge a signature. Because if that is the case, then it's not worth forging. So most systems are designed, most good systems are designed in such a way. So how does this translate into the artifacts we use to create physical signatures? We use good paper, we use pens with archive-proof ink, for example. That is one of the elements to make sure that somebody who's joking doesn't use his or her own pen with ink that disappears over time. So typically, if you go into contract situations, there is an unofficial pen that is used where everybody is in agreement that the pen contains proper ink that will not disappear. So physical signatures have papers, pens, archive-proof ink. And then there's also nuances in the levels of security of physical signatures. You can just have if I want to agree something with my kids, we can write it on a napkin and then, we sign on that and that's about it. And that also goes quite far away, a little bit depending on the legislative system. for example, in Sweden, an agreement signed by parties in an app on a napkin in a restaurant is perfectly valid as a business agreement that the court of law would later on say is enforceable by either party. To that extent, Sweden is very special that even a verbal agreement is considered a fully fledged business agreement. There's no need to validate signatures and so on. If it can be proven that something has been promised in a conversation, that is as good as a written contract. However, to improve on the security of a signature, one can have witnesses. So if, for example, Bimo and I are signing a contract, then we can have independent witnesses putting their signature to vouch that we were both present, we were both in good mental health and knew what we were doing when we were signing that. That in some cases is required by law to improve on the quality of a signature. Then we come to signatures that come from companies. In certain legislations, it is a requirement to have a company stamp put on them. It varies a lot from jurisdiction to jurisdiction. Where I come from in Serbia, it is very common that both authorities and businesses have stamps which need to accompany a signature of a director or something like that to make it a valid commitment on behalf of the company. And if we take this forward in international situations, if I were to send a contract or send some kind of document from Sweden to Indonesia, it is very likely that that document or my signature would not only need to be witnessed by anyone, it would need to be witnessed by a so-called notary public who has respect and the authority appointed by the Swedish state to vouch for cross-border signatures and also vouch the authenticity or the changes and things like that. So these are the kind of 4 broad types of signatures. Ordinary, just a signature on a piece of paper. Witnesses, where we bring some additional people to witness the intent and the legal and the mental capacity of the people signing. Stamp as a matter of representing an institution and organization in combination with a handwritten signature, and then witnessing by a notary public or perhaps a court of law or some kind of legal institution appointed by the state to be trusted into validating or vouching that the signatures were performed in goodwill and correct. And then there's always the question of where the signatures are stored, where the contracts are stored. There's a huge variety of options here. Most contracts end up in some kind of filing cabinet somewhere. There's always the one or the other anecdote about testaments being misplaced or forged or things like that. So storage has always been a questionable thing. And given that we're talking about physical signatures, they're typically done on paper. Paper is notoriously sensitive to water and fire damage. So any kind of archiving system needs to take that into account. But one way or the other, the signatures are stored on the paper they were produced on, and then hopefully one is able to retrieve them when one needs them. If we then have a look at e-signatures or electronic signatures, the first question you might ask, why bother? Physical signatures have been with us for several thousand years, at least since paper or paper equivalents were invented. Why change it? It's the speed and convenience of doing business that make a huge difference. And I'll give you a simple example. Sweden has a strong tradition of a good tax system. and it also has a population that is aging quite quickly. So when I moved to Sweden 30 years ago, everybody was doing tax returns on paper. So once a year in May, you submit a tax return for the previous calendar year. And that was done on a pre-printed form from the tax office, which already at that time already included all the information from all the employers and banks and so on. So that the integration between the tax office and the employers was electronic even 30 years ago. But it was nevertheless a piece of paper sent by post to my residential address. And then I would fill in any gaps or additions. And I would either deposit it physically at the tax office in Stockholm or send it by post. And typically, most people would make 1 or 2 errors in these tax returns, and then they would get a letter back from the tax office saying, you need to correct this. And then they would make amendments and send another. So already here you see there's like 4 physical letters being sent back and forth, which is very expensive and very slow and very inefficient. So with the aging population, the tax authority realized some 20, 25 years ago that they would not be able to handle the volume of tax returns and provide a good service to the citizens if they continued down the paper path. And the same applies to the social security, where you apply for benefits, childcare, sickness leave, and so on. All of those systems needed to be digitalized in order to be able to cope with the volumes at the same time where more people are getting retired and there's not enough people to handle everything. So that is one of the big drivers of digitalization, and thereby a big driver of being able to substitute paper signatures with something that is electronically manageable, but equally valid from a proving standpoint. So if we follow the thought process when it comes to electronic signatures, there is still a phase where we prepare the content and decide who needs to sign what. If it's a tax return, then typically I would get an electronic form from the tax office. I will again fill some gaps, but instead of doing that in a paper, I would do it online. And then once I'm happy with my tax return, I would need to make sure that I see what I'm signing. This is this WYSI-WHIS acronym, or what you see is what you sign. So something we take for granted, if you're signing something on a piece of paper, you're actually physically holding the document you're signing. You can put initials on every page, and you can sign on the final page as your commitment to the content of that document. When it comes to electronic elements, what the person signing needs to be able to see what they're signing. And this is an area where quite a few electronic signature systems have challenges, because somehow if you're signing a 300-page document printed on paper, the legal system can easily argue that, yeah, we expect you have read all 300 pages and you understand what you're signing. But if you were to take those 300 pages and present them in a mobile phone, that is a different challenge. Then one can theoretically argue at the court of law is, I couldn't have possibly been expected to understand and read 300 pages of text in a mobile phone. So this, what you see is what you sign, is a very important component of electronic signature systems to make them valid end-to-end. Then, provided that we created the signature, there needs to be electronic means to detect changes after signing. And there we are entering the world of classic cryptography, symmetric and asymmetric cryptography, And probably in the future, we are now touching on the borders of quantum cryptography as well, as both as a threat to classic and a possibility for the future. But one needs to have an effective means of detecting changes that may have happened to a document after signing. Furthermore, we need to trust that the signer is the correct individual. If you sign a contract in a physical world, typically that may require you to present some form of physical ID issued by a government that there's a mutual trust into. If you're doing cross-border signatures, there will probably be some kind of KYC process, know your customer process, which will require you to use a passport from a country that has good quality passports, so that we can know who you actually are, and thereby can trust that not only is the digital content of the document correct and the digital signature is correct, but also that the signer is the correct signature and not an impersonator of some sort who has managed to acquire a digital identity and thereby impersonate me or someone else over the web. Now, one very important thing or a couple of things to think about when considering digital signatures, and that is what is the value of the document that is signed? As in many other aspects of life, there is no one size fits all. It's very easy to go for the highest of securities and for the most expensive of solutions because that's the best. But then very often that ends up being an overkill. So if the value of the document is $5, then it will require a different complexity and a different level of security than if the value of the document is $15 billion. It's completely two different things. The other thing to consider is how long does this need to be protected? If the information is of value for a short period of time, one can use a simpler and less expensive digital signature system than if the document needs to survive centuries. For example, property transfer, buying a house, buying land. That is something that may need to be proven not by me, but by my children or by my children's children or by my ancestors 200 years from now. They need to be able to bring up the property transfer document electronically and prove that it's correct. And then, unfortunately, due to Zoom, it doesn't show the last one, and that is, it's very worthwhile considering who the potential adversaries are. So if I'm trying to protect something from my kids, I can use something reasonably simple. If my adversaries are, organized criminals or in some cases, foreign government entities, then I may need to deploy stronger means of protection to make sure things are working as they should. So this is what brings us then to the first of the 5 points I would think that one needs to consider when choosing a digital signature system. On one side, there is simplicity, and there are a number of systems out there who attempt to mirror the physical world electronically. I suspect that you have had contact with DHLs or UPSs of the world delivering parcels, and very frequently they have small handheld machines where one draws one's own signature on a screen as a matter of confirming that one has received a parcel or a letter. There are also digital signature systems which ask you to do that on screen, somehow draw with a mouse your signature. And that is relatively simple. It doesn't require any special equipment on behalf of the signer, and can be used in some circumstances. There is even options where you're in a browser just required to type your name. I frequently compete in triathlons and Ironman competitions, and at the registration, to confirm my intent and identity, the only thing I need to do is to enter my full name and surname typed on a keyboard in a specific field. There's no kind of signature and so on. That is what Ironman has decided is good enough to prove my identity. I guess the drawback of these they're simple for the end user. You know, although the signature one draws with a mouse is probably not very pretty, and for most of us it doesn't look anywhere close to our signature done with a pen. It is simple. It doesn't require any kind of special equipment to perform, like smart card readers, mobile phones, or anything else. You know, a browser and a PC is enough. The drawback is not very easy to validate this electronically in a way that is cryptographically secure. And consequently, it is seldom easy to prove this in court. At least, you know, in Europe has specific legislation when it comes to levels of trust in signatures and technologies and so on. Something drawn on the screen would have difficulties to be proven in court. On the other hand, we'll come to that consideration in a few moments. If it's for internal company use, then you probably don't care about courts. You want to streamline internal processes or approvals and so on. On the other hand of the spectrum is typically trust. And what I'm implying here is the higher trust one puts into digital signatures, the more complicated it gets. So it's directly opposite to simplicity. And in order to trust something, then you often mix some form of specific hardware, like one-time tokens or tokens with a pin pad where you need to enter a pin before they display a one-time code. It may require asymmetric cryptographic solutions, so digital signatures based on specific asymmetric public key cryptography, where you have a private key which you keep hidden from the rest of the world, and a public key which is distributed that can be used to validate signatures. It probably involves standardized formats for the underlying content. So there's this CMS standard, also known as PKCS7, XML digital signatures or PDFs. They all have their own ways of saying, given a document, this is what a digital signature looks like. The beauty here is, although it's more complicated than the simple side on the left-hand side, those are standards, and thereby if, for example, BMO and I both understand one of these digital signatures dialects, we will be able to interoperate, and I will be able to produce a digital signature, send it to BMO, and he will be able to validate it. Then we have the question of, you know, long-term storage and trust in how long a signature can be valid, where there's a number of standards which cover. And for the three that I've just talked about, CMS, XML digital signatures, and PDF, there exist long-term storage variants called CA-DES, XML advanced digital signatures, and PDF advanced digital signatures. So there's been some considerable thought and engineering behind, all right, we need to create a digital signature that can be validated now, but there needs to be means to make sure it can be validated in 100 and 500 years ago, and this is how we're going to do it. That is what these three are. So that increases the trust of the produced signatures. Now, all of the above typically need public key infrastructures. So I mentioned the asymmetric solutions where you have key pairs with a private part and a public part. That is just technology. At the end of the day, somebody needs to tie a specific key pair to a real life identity, and thereby bind the two such that when signatures are produced with this electronic means, we know that with high assurance that they have been produced by this specific physical person, which is then what brings us to trust levels in terms of how well the issuance process of the electronic identity has been performed and how good the technological means of conveying the digital signatures are. Europeans have defined a standard that is called eIDAS, where there's 3 levels for both of these: low, substantial, and high. And as I said, they cover 2 areas. One is, how does an individual acquire an electronic identity? What is the process? What kind of evidence do I need to produce for somebody to issue an electronic identity in my name only to me? And depending on how difficult it is and what kind of evidence I produce, there can be low, substantial, or high trust in the issued digital electronic identity. And then there's the other part is, okay, that electronic identity can be used to produce electronic signatures, which can be of low, substantial, or very high trust. The beauty of the European system is that if one has used eIDAS, an identity with the eIDAS high, and has produced a signature according to the eIDAS high signature formats or processes, then the courts of law will automatically approve that signature. It is up to the person who is challenging that to prove that it's wrong, that something is not okay. So that is a very interesting legal aspect of handling trust levels. But if we summarize, on one side, there is simplicity of use for the end user and for the issuance process. Not simple to validate electronically and probably difficult to prove in court. On the other side, there's higher trust, but more complexity technically and issuance-wise to bear. And where on this continuum you choose to use your system will depend on the 3 questions I asked or mentioned previously. How long? What's the value? And from whom are you protecting the document from? Then we come to the internal versus external consideration. So by internal, I typically mean what is digitalizing a process within an organization. It can be within Ericsson in Indonesia. It can be within Tetra Pak in Indonesia. We want to digitalize the purchasing approval, or we want to digitalize travel expenses, and we don't want to fill those on pieces of paper anymore. We want to do that internally. That is typically of interest inside the organization. One wants to reduce the manual processes, paperwork, and so on, to make bookkeeping and audit more effective and easier, and so on. And that is one consideration. So you don't need to interoperate with anybody. You can choose a system that just works for this specific company. And that automatically implies it's going to be simpler than something that you need to interoperate with others with. Another example of kind of internal use, although counterintuitive, is typically banking. So banks produce systems where they authenticate users logging in for internet banking. But it is seldom they need to prove this to somebody else. It's for their internal use. They need to prove it to auditors and maybe the regulator, that they have good control over how they issue digital identities, and that people logging into the internet accounts are indeed people who are supposed to log into them and transfer money and so on. But it is an internal use within the bank. On the other side is all right, we are producing signatures in one organization, but they need to be consumed in another. And that brings us to the discussion I had previously on standardized formats. It's very difficult for any actor in an ecosystem to impose a format which is not standardized and ask the others to follow. Given that there's been a lot of work on standardized formats in the standardization communities, and CMS, XML, DSIG, and PDF signatures are three most common electronic formats, it would be suicidal if a party in Indonesia suddenly said, no, we're going to use something completely different, and then ask external parties to comply. So that's where standardized formats come into play, but also trust, because on the left-hand side here, we need to trust our internal issuance processes. If we're giving the electronic identities to employees of the company, we need to know that the onboarding and offboarding is correct, and not that some employee who was fired 3 months ago can still access electronic records and so on. When it comes to external, that's a bit more complicated, because suddenly you may be receiving digital signatures from parties who have from individuals who have acquired their digital identity from someone else. So you need to trust that. And generally, the trust levels that one has in any given geography are governed by, the document properties and purpose, any kind of governmental frameworks and/or law. And already, even in Europe, where I mentioned that quite a lot of work has been done by the EU Commission to standardize formats, there are different legislations. And as I said, Sweden is very forgiving in terms of the formats of signatures and what is accepted. Some other countries like Austria and Germany, they really insist on what is called qualified signatures and the EIDAS high and so on, because their legal setup is completely different. So if one is planning to digitalize something that works across boundaries from organizations, then one needs to consider the laws of the country, any governing frameworks that the government has created, and what are the properties and purpose of the document. Then we come to local versus remote signatures. So now we're talking electronic signatures. Those are typically done with cryptographic keys. Cryptographic keys need to be stored somewhere to be used. And on the left-hand side, what I'm saying is that if I'm signing the document, I am signing the document with keys that I physically possess, hopefully in a secure way, on a USB stick, on a smart card, protected on a secure enclave of a phone, or somehow well protected on my local PC or storage that I have. But the keys are physically under my control. I have them in some way. No one else has them. There's often limited format flexibility, because using those keys locally typically requires some software to do so. So if you have a smart card and a smart card reader, one will have to have a smart card software on the PC or Mac or Linux or whatever computing platform. There will need to be drivers that are able to communicate with the card. The card will need to be issued in some format that the drivers and the reader can understand. So there needs to be dedicated software on the client, and the format that client can produce is usually very limited. So you cannot, if the client software doesn't support XML, then you will have difficulties producing that. Here I'm mentioning two Swedish solutions, Freja eID and Bank ID, as issuance of digital identities. They actually use this setup with local keys under control of the individual. And consequently, they have very fixed formats. With Freja eID, one can create a yacht signatures, JWS. And with Bank ID, one can create XML DSIG. And together, they cover about 95% of the Swedish population in terms of electronic identities. And I'm afraid I didn't translate the last sentence here. The limitation is that typically these local solutions are signing simple text. Sometimes with advanced middleware, one can actually sign PDF documents, but in most cases, the content is simple text. On the remote side of things, and that has only been growing in the past 5 years or so, one has come to the realization that securely storing keys in hostile environments, such as an end user's laptop or a mobile phone, which are both internet connected and are vulnerable to various attacks, is maybe not the ideal ways to do this. Maybe we shall keep keys in a central location where one can deploy strong cryptographic measures, protection processes, and so on, and then give the end user the means to approve the usage of such keys. And that also gives us a lot of format flexibility, because how the keys can be used in a central location can produce different types of signatures. The eIDAS framework allows both for qualified and advanced signatures. One also decouples document handling from producing a signature. So one can build an ecosystem where one has a platform where we agree on what is going to be signed, and when it's ready for signature, it is passed to a platform which actually prompts each of the signers to sign with central keys. And I'm not sure which side I should move to so you can see this text here. There's two examples of ecosystems like this. One is the Oasis Digital Signature Standard, which is XML based. And the other one is Adobe Cloud Signature Consortium, who establishes identities on OAuth 2.0. But both of these allow for central keys for signing. In terms of hosting everything, whatever kind of digital signature one selects, you'd need to consider how to do it. Historically, on-prem has been dominant, which usually implied procuring complicated hardware, certificate authority systems, issuance, and so on, expensive, complicated, and apart from the most technically savvy companies and financially rich, it's a difficult path to take. Perhaps if one is performing own digitalization with one of the simpler solutions I mentioned, in those cases it makes sense. Anything that involves the acronym PKI, which one needs to host internally in a company, is very difficult and expensive long term. Then there's the cloud setup, where there's a lot of packaged solutions which provide digital signature capabilities, usually with a fixed user month flat fees, sometimes based on the number of signatures. They allow for flexible flows in terms of how do you set up documents for signing, what are the processes, how do you delegate a document to somebody to sign, and so on. In most cases, these are geared towards producing PDF signatures, as these are the common way of being able to render what you see as what you sign. And then there's various ways of performing these signatures or identifying the signer. You can use electronic identity, you can confirm something with SMS, you can draw something on screen, and they all come with varying degrees of trust that I talked about earlier. And then obviously there's a hybrid variant where, for example, one can use an electronic identity setup hosted externally, but has one's own document preparation systems. So you prepare the document signing internally, and then you use an externally identity scheme. And most government agencies in Sweden use this flow. They don't issue their own electronic identities. They have own systems for preparing digital content for signing, but they rely on external signature providers to produce the signatures. And then one thing that we've touched upon just a little, and it's the final point one needs to consider here, is in what capacity am I signing? All right, my name is, as you've heard, Dragoljub Nesic, but I have different personas that I represent in different situations. Right now, I am representing Stockholm University. In my day-to-day work, I would represent Skippo, the company I work for. In my private life, when I look at pension benefits or when I talk to the tax office, I represent myself. And the electronic identity I use needs to reflect that. It is not ideal if I use my private electronic identity to represent the company. So in what capacity people are signing something is a consideration one needs to take into account, because that will affect privacy, where my personal data is stored, how to release as little information as possible about the signer, but have enough that it's valid in a document, and so on, and also the context of use. So if we summarize, we talked about simplicity versus trust. We talked about the formats. We talked about how to host this on-prem, on cloud, or hybrid, private versus contextual employment use, representing your employer, or whether it's the government or a private company. All of those things need to be, at least questions about each of these options needs to be considered before saying this is an ideal electronic signature solution for what we're trying to achieve. And always keep in mind, I will say this once again, the three questions I mentioned: how long something needs to be protected, from who, and what is the value? Because in my experience, very often people select too complicated and too expensive solutions, which ultimately fail to protect documents which are not worth it. So just be pragmatic and take that into consideration. So sammanfattning is the Swedish word for summary. Use standards if you need to exchange signatures with others. Definitely think twice before you decide to host any kind of signature system yourself. And make sure that if you're signing in a business context, you should use a business issued electronic identity. With that in mind, I think we've reached exactly 8 o'clock in Jakarta. So I don't know whether we've had any questions so far.
I have few questions sent to me by my colleague, Nessa.
Yes.
And yeah, I think I will just ask you directly the question.
Yes, please.
Yeah, he's asking, my colleague asking whether the digital signature is considered legal or fully legal, particularly if it is a cross-border transaction involving two different legal systems.
It depends. It depends what cross borders are we talking about. If we are talking across European borders, then yes, the signatures produced according to the eIDAS regulations must be accepted by entities in all the member states within Europe. So both on a technical and legal level, there is a good level of understanding of what interoperability looks like. In terms of exchanging, for example, electronic signatures between Sweden and Indonesia, on the technical side of things, I think we wouldn't have difficulties understanding. Where we'd need to figure out how it works is the assertion of trust into how the identity was issued to a given person and how that is sorted out. So I don't think there's any particular government agreement covering that. So technically, yes. From a legal standpoint, I don't think it would work to exchange that. You'd probably need to get some kind of notary or paper trail in international contexts.
So it may involve or it should involve legal agreement between the countries or the institutions involved.
Well, exactly. So if you're looking at, there's various initiatives in different parts of the world that I've seen over the past 20, 30 years. The United Nations has a system for placing electronic orders, which are cross-border and transfers and so on. So I think if we are able to agree on money transfer through various systems and interoperability there, both legally and technically, then long term there shouldn't be any issue about interoperating at the digital signature level as well, both technically, which is the lesser of problems, and trust-wise in terms of knowing that the person you are whose signature you're accepting is indeed who they claim they are.
Okay, quite interesting. And we have one question from our participants from Eddie Novendra. You may see on your screen, Nessa.
Yes.
Yeah, he's asking about level of responsibility for the party who just affix the initials compared to those who fully sign according to the law or legal system.
Well, to be really fair, I don't think those are separate. I mean, at least in my experience, you use the initials when you initial like a multi-page contract as a means of making sure that, yes, I've seen this page and I put my initials on it somewhere just below the final line of text. So one cannot add another line of text below that. And then I put a full signature on the final page. I'm not aware of any context where one person would be doing the initials and somebody else would then put the full signature on it. So I think the initials are typically just a way to say, yes, I've seen this particular content. And in some jurisdictions, it's common. In some, it's very uncommon. In Sweden, putting initials on every page is very uncommon. You typically just sign the final page of the document and there is trust that the other party is not going to fool you. In some other places there's more kind of less trust, and then you put the initial on every page and the signature on the final one. But I'm not aware of any case where, for example, BMO would be putting the initials and I would be putting a full signature on the document.
Okay.
I hope that answers your question.
Is it answering the question, Eddie Novendra? If not, then you may ask your follow-up question. Oh, okay. I think he is happy with the answer.
Good, thank you.
And talking about the digital signature, I think we may consider the risk associated with this implementation of the digital signature. What are the risks or the most higher risk that we should anticipate if we are going to implement this internally or externally?
Well, there's two main processes in this. One is the process to issue a digital identity to someone. And the other one is the actually applying this electronic identity to create a digital signature. And the attackers will typically attack the weaker of the points. So it has to be consistent throughout. The attacks on the issuance side are obviously impersonation. So if somebody is able to acquire a digital identity in my name, then by definition, they can assume my identity in a digital context and maybe open a bank account, take a loan, and run away with the money. So that is the kind of identity theft is one consideration to have in mind. It's probably not very different from the physical world. I mean, in a physical world, you can have impersonators fooling the system and getting a government official ID on because they look like me and have a witness or so on. So it's no different to the physical world, the issuance process. It's just that you can apply it at a larger scale faster. So if I get a digital identity, I can open a bank account, take a loan, buy a car, do many things in a very short period, transfer money, and then disappear. Which, if you just have a physical ID, is more difficult. So those are the risks on the issuance side. What is the process to issue a digital identity? And then on the technical implementation side, how do you assure that what the person is seeing is actually what they're signing, that there's no funky stuff going under the surface, and that the digital signature produced, that the keys are kept secure. That is probably one of the larger concerns when it comes to the digital identities that are issued. How secure is the platform containing the keys or the control mechanism of the user to use keys? Is a mobile phone a good enough platform to hold keys? How secure is a mobile phone? Do keys need to be stored on a secure element, which, like a smart card and so on, that is governed by the amount of trust or the requirements of the application or what you're signing. So, as I said, two areas of risk: the issuance process and the deployment process, that need to be considered and make sure they match the risk profile you're willing to take. And on the other hand, you've got the benefits of digitalization to take into account for. So if you save $10 million because you have digitalized the process, then maybe you can accept $1 million in identity losses or theft. You still save 9. So that is a kind of balance that one needs to strike here.
Okay, we have a question. What security policy or standard are generally used in the use of digital signing? Well,
I mentioned a few standards in terms of both the formats, like PKCS7 or CMS, XML, DSIG, PDF, digital signatures. Those are all well-established technical standards internationally. In various jurisdictions, there are various standards for issuance and usage. Like in Europe, we have EIDAS. The Americans have various NIST standards which govern how identities are issued and what technical standard signatures need to have, and what standardization the equipment that deals with keys needs to have, and so on and so forth. So I think most countries outside of Europe and US adopt some of these standards which have already been put in place, which are delivered by ETSI, the European Technical Standards Internet, or ANSI or NIST in the US, as they have been well thought through from both a legal and a technical perspective.
Okay, we have another question. The previous one, I think, from Mas Raisulia, and now we have question from one of our participants from Yofi Manova. He's asking, what is the digital signature provider responsibility in terms of, or if there is legal or law dispute in any country. For example, Adobe. Can anyone ask Adobe to witness in the court?
Well, most likely, yes. I mean, if you're using Adobe software as one of the links in the chain to produce a signature, you would probably be able to get them as some kind of expert witness or in a court of law. Adobe itself doesn't issue electronic identities or produce digital signatures. They have software which invokes other parties which have issued electronic identities and which perform the signing, and that is embedded in the PDF, resulting PDF. So to what extent, they would be willing to come as a witness in a court of law is a good question. If you have if you're licensing their software for some purpose, and you have a support agreement, then probably yes. If you're using a PDF reader without a license, although I think a classic PDF reader cannot produce signatures, so you need to have a license and since then you're a paying customer, there is a contractual relationship where a court could actually summon them as a witness. So.
Okay, and another question, I think, on the screen from one of our colleagues is asking if there is a risk if the device or software that we use for digital signature is infected by malware.
I think the best answer here is it depends. Again, on the complexity and so on. On I think smart cards with FIPS certified or common criteria certified chips are very unlikely to get infected by malware in their own right. So the keys can be considered very secure if they are stored on a certified hardware element with good middleware. Where the infection may occur is in the platform that's communicating with the smart card. On the other hand, if the setup is done correctly, it would be very difficult for such malware to modify the content or cause any concerns. I've certainly seen very high-end systems where the smart card is inserted in a reader which has a PIN pad of its own. So it's self-contained and you don't enter your PIN or password on the general computing platform where that is just displaying the document to be signed. So if we're talking about PC platforms and software storage of keys, then yes, obviously PCs and Macs and everything that is internet connected, it's not a question of can it be, but when it will be infected by malware. I think recently there was an attack published on even on iPhones, which are generally considered a very secure platform, where one could have a zero-click attack. A good crafted iMessage or previously a good crafted WhatsApp message could install malware on a perfectly good iPhone that wasn't even rooted. So anything that is internet connected probably can and will be infected by malware at some point in time. And our job as technologists is to minimize that likelihood and to make it difficult, and as I said, make it more expensive for that malware to do damage than what it can gain from the infection. So
yeah, I hope it's answering the question from Mas Rais Yuli, I think, or our college. And another question from one of our participants from Yofi Manova. And he's asking if there is any example case in digital signature law dispute, and what is the result?
To be really fair, I've been looking forward for somebody to challenge digital signatures in a court of law. However, court processes are frequently very expensive. I'm aware of a few users which have sued Bank ID, claiming that they haven't performed a specific action. But in all of those cases, I think Bank ID could prove that the user was grossly negligent, leaving their device outside of control or giving their device PIN to somebody else who was able to impersonate them. I'm not aware of any case where the issuer has been found guilty of technical faults, or at least in Sweden. And if I look at the final question, there's one from Rahmat here.
Yeah, from our college, Mas Rahmat
Yes.
Mulyana. Yeah, your college.
Yeah, so from a project management, experience to cope with challenges from a business and technology perspective. I think Sweden is a brilliant example of good digitalization. I mean, we're a country of 10 million people or so, and we produce several billion electronic transactions every year. So the society is very, very digitalized. There's very few paper processes and so on. The challenges we've had is that in Sweden, there is this unique number that each citizen has called a personal, it's a civic registration number, something you're allocated at birth or when you move to Sweden, which is then used in a lot of interaction with government or with other parties. And there are two forms of that. One is for permanent residents, and one is for individuals that are temporarily here. And the temporary side of things is not working very well. So there's about 1 million people living in Sweden which have difficulties with interacting electronically with the government and other entities. The second area of difficulty with digital signatures in Sweden is people which are not fully legally capable for their action. Maybe they are intellectually challenged, or they have been appointed some kind of governance by a court because they cannot take care of themselves. That situation, there's about 100,000 people in Sweden which are practically outside of the electronic society. They cannot act on their own behalf, and the delegation system is not done very well. Other difficulties are acting on behalf of someone. So if my elderly mother would want me to act on her behalf, that is a different challenge. It's not an electronic identity challenge. It's being able for her to delegate the authority to me, her son, to represent her towards the retirement, the pensions agency or the tax office or something like that. Those systems are not fully in place. So I think from a technical perspective, there's few challenges. There's two good options. Competition is always good. The challenges are on including people who are on the edges of society, handicapped under a legal guardian, and maybe people that have recently moved to Sweden, which are or temporarily here to be part of the society. And I think any society is only as good as it handles its edge cases. So we can certainly do better here.
Okay, I think we have answered all the questions from participants. Once again, thank you very much, Nesa, for your time, insight, and sharing your knowledge and experience to us. And before we close the webinar, we will have a photo session to make a memory of our event tonight. I will
So
ask
do you need me
Mas.
to stop sharing or?
Yeah, I will ask Mas
Yes.
Julie to help with the photo. And please turn on all your camera. Can say hi to any of our colleagues. You
Okay.
see familiar face on the screen.
Okay, I will screen. Okay, this is the first page.
How many pages, Mas Julie?
The second page. Wait. Okay, this is the last. Okay, thank you.
Okay, thank you very much all
Thank you
for
for inviting me.
joining. Yeah,
It was
thank you,
great being
Nessa.
there.
And
Yeah.
yeah, please send the file that you want to share with the participants.
The
You can
presentation?
send. Yeah, you can send. You can send to me.
Okay, I will do that.
Yeah, thank you
you,
very
Bimo.
much
Take
all.
care.
Thank you, Nessa,
Thank you,
for
Nessa.
your
You're
time.
welcome. Bye.
Yeah,
Have a good
thank
day.
you. Mas Rahmat, makasih.
Thanks, Nessa.
Makasih ya, thank you.
Oke, Mas Raisuli, saya live ya.
Ya, terima kasih semua.
Oke, thank you
Selamat
all ya.
malam. Oke, saya live ya. Saya end meetingnya.